Ladies and gentlemen, welcome back to the Indie Zone. After the case proceeded for more than 2.5 years of pretrial, two key events happened that led to the closure of the case in lieu of the jury trial, where the state of Idaho would be required, as our country's founding documents, the Constitution, mandates, and that is to produce evidence in a court of law that Mr. Kohberger and Mr. Kohberger alone, in what was then a capital case, was the correct and the sole person responsible for the catastrophic events at 1122 King Road. On July 2nd, Mr. Kohberger pled guilty to all 5 of the serious first-degree felonies he was scheduled to stand trial on. And shortly thereafter, on July 23rd, Judge Stephen J. Hippler sentenced him. Since then, there's been much discussion regarding, will Mr. Kohberger appeal his conviction, notwithstanding the fact that he, in his plea agreement with the state of Idaho, agreed to waive appellate rights. But as Judge Hippler stated, words to the effect that a waiver of appeal does not necessarily mean that an appeal cannot occur. And he cited directly to Garza versus Idaho, which is a 2019 case where the Supreme Court of the United States recognized that no appeal waiver serves as an absolute bar to all appellate claims. But the High Court has made no statement on what particular exceptions to an appellate waiver exist. That is a matter at issue in the case styled as Munson-Hunter versus United States that is before the Supreme Court right now. Mr. Hunter cited to Garza, and the questions presented in his case are: 1, whether the only permissible exceptions to a general appeal waiver for claims of ineffective assistance of counsel, or that the sentence exceeds the statutory maximum. And that is how the appellate courts across the country have interpreted Garza to stand for. The other question presented for SCOTUS's consideration in Hunter is whether an appeal waiver applies when the sentencing judge advises the defendant who has signed that appellate waiver that he has a right to appeal, and the government does not object to that judicial statement. As of this time, there is no indication that Mr. Kohberger intends to file an appeal of his sentence. However, in the event that he does, it will not be Garza that is cited in any future appeal. It will be Hunter, because this is the case that now looks at Garza and will afford a ruling directly from SCOTUS as to under what circumstances could a defendant who has signed an appellate waiver still appeal a sentence. However, the Supreme Court has not yet rendered its decision in Hunter versus United States. That decision is expected on or before approximately the end of June 2026, at the very latest, the beginning of July because that is the time frame when the Supreme Court has historically closed shop for the year and will not reopen again until October of 2026, when a new year's worth of petitions will be considered. So in short, Hunter, not Garza. Until next time, thank you for joining us here today.